Ladies and gentlemen, just hold the question just a little bit. Let me introduce for the moderator who's going to lead the panel discussion as we speak some more about the poker and anti-money laundering initiatives to be introduced. We have with us who's going to lead the panel discussion on both presentation, which is poker anti-money on the new regulations that Amina spoke about earlier. We have with us Dr. Shazida Ali. Is a senior lecturer in the Faculty of Law at the University of the West Indies, Mona, and a course director at the Norman Manley Law School. For 6 years, Dr. Ali served as a technical advisor in the Attorney General's Chambers of Jamaica, where she was involved in the process leading up to the enactment of the Proceeds of Crime Act, Poca. Dr. Ali is the author of the book Money Laundering Control in the Caribbean and the editor of the book Risky Business Perspectives on Corporate Misconduct. Dr. Ali holds a Bachelor of Laws degree from the university, a Master of Laws LLM from Cambridge University, and a doctorate from the University of London. Let us welcome Dr. Ali to the podium, and she will be joined by our support team.
Thank you, Mr. Shirley. To join us in responding to your questions, there are two other distinguished panelists who I'd like to invite now. First is Mrs. Andrea Martin Swaby, who is an Assistant Director of Public Prosecutions at the Office of the DPP. She obtained her Bachelor of Laws degree from the University of the West Indies and is also a member of the government service since 2006. She initially served as a clerk of the courts in parishes of St. Anne, St. Catherine, and in the corporate area before joining the office of the DPP in September 2008. She has received specialist training in poker and has also been involved in doing presentations on the topic to persons such as yourself. In addition to Mrs. Swaby, we also have Mr. Maurice Thompson, who is a Senior Inspector for Enforcement at the BGLC. Mr. Thompson has worked at the BGLC since 1993. During that time, he has worked across all operational divisions of the Commission. He has been assigned to the Enforcement Division since 1999, where he holds the post of Senior Investigator. He has a degree in Business Administration from the University of Technology and a Master's in International Business from the Mona School of Business. He's also an adjunct lecturer at the UWI in International Business Management. He has extensive knowledge of the gaming industry, both locally and internationally. So I'm sure you'll all agree we have a very distinguished and knowledgeable panel, and they're ready to take your questions. If you could just identify yourself and state where you're from when you ask your question, that would be helpful. Okay, I think the first question is over there. Thank you, go ahead.
I'm Dr. Jefferson Ford, Langford Orleans, and I am going to give. Madam President, do you allow more than one question per person or questions linked together, or you only want to answer?
Well, we'll hear them. Go ahead.
This question has to do with what the first president spoke about in respect of the ticketing system.
Yes.
We know that during the police normally get traffic tickets, and she's only made the annual. That you don't bother, just pay the fine, otherwise you lose 2 or 3 days. If your commission plans to introduce a ticketing system, and you make it such that the fines, if you're challenged to go to court, you actually penalize the thief by going to court. In other words, pay the fine, pay $1 million. Because if you go to court, even if you're right, you run a risk of $2 million if the judge will agree with you. That seems to set in place a system where you're saying to people, go ahead and pay the fine because you can't be bothered to do what might be the right thing to do by virtue of how the system is set up. The second question, in regards to money laundering.
Could we have Mrs. Macklin respond to that question first? Thank you. Mrs. Macklin.
Hello?
Can you hear me? Does that work? You want to come up here? You want to come here?
Respectfully, I'd have to disagree that it's a discouragement from persons doing what they believe is the right thing or standing up for justice in a particular situation. The resident magistrate, the resident magistrate's powers cannot be fettered, so therefore he or she has the power to impose a fine up to a particular limit, and that is to facilitate them, having assessed the whole situation, when the matter goes to court, in the event that the person does lose the case, that they can increase the penalty that was originally imposed by way of the fixed penalty, or similarly decrease it depending on what may be mitigating circumstances. So that facility is there for discretion by the resident magistrate. And we are also engaging with the Courts Administration Service as well as the Tax Administration Service to ensure that the fixed penalty system works in an efficient manner. So we've had discussions with the Chief Justice to try and ensure that resident magistrates' courts across the country are cognizant of the fact that these types of matters are going to be coming before them, and it's expected that there will be certain days in a month in which these matters will be taken, so as to facilitate the smooth process through the courts as much as possible, although we all know that our court system is already burdened. Yeah.
Thank you, Mrs. McNaught.
I would think satisfied that we will discuss that way. In terms of money laundering, sure that depends on the next presentation. That's our fault. But in terms of national system, like all of us are going to put Russian oligarchs, unlimited amount of cash, a state-controlled money laundering. You see the Chinese maybe buying out Caymanas, state-controlled money laundering. But then implications when we are tied into a national system that launder money. That's why that indictment last week by the Americans of the Chinese for they might never bring them to America. But the fact that they are recognizing that national institutions can bring about money laundering. And what is the implication for us then in terms of accepting money from people outside? I'd like to get Russians to invest in Port Henderson. Am I going to be guilty of money laundering because their national system allows them to launder money?
Okay.
And the final question, if I may. We have seen that this one is directed primarily at the minister.
Oh, okay. Go ahead.
As a minister, we have seen where the government, my government unfortunately, has put in place in another sphere, Reefing Trust, FinSac, Jamaica Redevelopment Company, selling out assets to people from abroad primarily, who may give rise to questions, how did those little guys be able to buy an apartment building? Is the money laundering act then going to mean that government will step back as pioneer and allow other institutions, by virtue of the ministerial fiat, to say the money laundering is really meant for us to be working to pay by the rules?
All right, thank you.
Jeffter, first of all, persons who are coming in, due diligence are done on all these individuals. In fact, we didn't get an opportunity to get into it today, but an important part of what you're going to have to do now is what we call our client or customer due diligence, knowing who you're dealing with. Also, all right, I can't answer to the past. I'm perhaps not as cynical and despondent as you are. But going forward, remember now too, I told you that the real estate industry has been brought under this regime now, and the legal profession. And they too will have the same responsibilities that the betting industry has in terms of before you do any business with anybody, you have to do a due diligence and know who the person is and satisfy yourself about that person's source of funds and what it is that person does. The ministers asked me to say that there is no such thing called state-sponsored money laundering.
Dr. Ford, there's one state which I will not name that I hear is the leading jurisdiction in counterfeiting. But I am not aware of any state in this modern international financial system that as a state, they're actively involved in the laundering of money. We do business with governments and with multilateral institutions. We do business with the Chinese Exim Bank, from bank to bank, state to state, etc., etc. And we don't, I'm not aware of anything called state-sponsored terrorism, money laundering.
Okay. Thank you, Minister. Did I see someone's hand?
Oral Shortly. It's just a question. I'm very concerned about one aspect of the money laundering that Shirley and Gideon made. If I go to Cabernet Park on a Saturday and I bet on a couple races and Cedric Strout CTL pays me from my proceeds of the winnings from those horses, $1.2 million. It so happened that my contractor, who did some work at my house, was there, knew that I won this money. I paid over the $1.2 million cash to him. Can I be charged $3 million for transacting a business with an individual who provides a service cash?
You know, prior to the introduction of that cash transaction limit of $1 million, because remember, no, you can't transact any kind of amount over that amount, no, in cash. You have to go get a negotiable instrument.
But they pay me in cash.
No,
You can't receive it. You're not allowed to receive it
they
either.
can't anymore, but CTL would never have paid it in cash in the first place. Not that kind of amount of cash. But let us even say that that amount of cash is paid over to you, and you in turn, your contractor did some work for you, and you in turn pay that cash to your contractor. Your contractor is going to have to keep that in a trunk under his or her bed, because no matter where you go, once you're going to put the money into the system at all, they're going to want to know where the money came from. So your source of funds. So your contractor will have to tell them they got the money from you. If they don't know who you are, or they may be suspicious of who you are, they may very well have to file a report to the authorities on the matter. Okay. Oh yeah, what people can do is, yes, you can pull out the trunk every day and pay little. Yes, you can do that also.
And $1 million.
Yeah, that's the thing, but you can.
But you say that's perfect, you can't do that.
Yeah, you ought not to do that, exactly.
Yes, but you have to pay your debts, and that's probably...
Yeah, but you don't pay your debts in cash. But these days nobody pays debts in cash, you have check and card. Or you can do inter-account transfers, You get a discount cash.
Okay. All right. Mrs. Webby, you wanted to add something?
You see, the difficulty is that the anti-money laundering regime discourages payments, especially regarding large sums of cash. It is better for you to go through the formal system, because the formal system is easier to be policed by the money laundering authorities. And so therefore, the betting, gaming and lotteries industry, those businesses are cash intensive, and that's the very reason why the Proceeds of Crime Act has been amended to capture not only this industry, but also car dealerships, accounting firms, etc. Because it's not that simple. You can't just accept $1.2 million worth of cash because you don't know the source of the funds, and that is the difficulty. And so money launderers will always be drawn to these institutions.
You are part of what are called gatekeepers. you know, because it's through you that the money can flow into the legitimate financial system. And so persons who are part of the regulated sector are sometimes known as gatekeepers. I saw a question. Yes.
Yes, ma'am. My name is Barbara Borland Williams, and this question is for Ms. Eaton. The last time we met, I'm now wearing my off-track president hat. We earn commission. So the more we sell, the more we earn. So we would like a little guidance from you. What do we do as OTB operators when someone has spent $1 million or more in an OTB throughout the day? For example, do we now report our customer? And we're going to lose this business. So we're caught between a rock and a hard place. Can you help me with this, please?
Well, the difficulty is that if they have broken down the transaction in such a manner, for example, if it is $1 million and they've spent $200,000 in each transaction, they could be considered to be smurfing. And what Section 101 says is that you could also be held criminally liable for receiving those funds.
So what do I do? Report these people? I'm going to lose my income.
You are now
I'm
capturing
earning
the
commission.
Yes, you have to report them.
This don't make any sense.
And in fact,
But Cameron needs money. Cameron needs money, you know. I mean, everyone is laughing, but this is not true.
Law is the law, Madam President. The law is the law. And between a rock and a hard place, the rock is a worse place. So you do what you have to do. I'm just saying from where I sit, the law is the law. And you cannot, or you ought not, to circumvent the law. You have a responsibility as a designated entity. You are there, you're operating a business to abide by the law. Because sometimes you are between the rock and a hard place, as one of my colleagues said, but the hard place is worst. Right.
Okay.
Well, Minister, I do not intend to go to Fort Augusta on account of Caymanas.
Okay, thank you, Minister. Question over there? Gentleman who had his hand up.
Good afternoon. All right, my question is Section 43C IT. I'm from Postal, sorry, and my name is Brian Bishop. Now, in reading the amendment, it seems that you're now saying everyone who provides any form of IT service must be registered with the BGLC. No, I have it wrong?
Yes.
Okay, so most gambling platforms aren't done locally. Europe tends to provide the bulk of that. Are we saying that if I ask my company to buy a software from a European company, that European company must be registered, or is it okay for me to buy it because my company is registered with the BGLC?
Okay, thank you. I think we have time for just one more. Oh, okay. I've been told that. All right.
Let me just be specific. It's any of those technical services in connection with any betting, gaming, or lottery activity taking place in Jamaica. Yes, indeed. The software providers, even if they are based overseas, will have to go through whether it is an approval or a licensing process that is yet to be refined,
so
but yes, indeed.
Jamaica in itself, yes, the gambling industry is big, but it's a small factor to a European company who supplies to Africa, Asia, and so forth. So you're telling me if I am to buy a platform to be in the good side, compliant with the BGLC, from a European company who my money is, although I'm a customer, I'm a small customer. He has to be registered with the BGLC, The fact that I can provide you with the software, sorry. The fact that I can provide you with the software, its makeup, I just say source code functionality, and access to that software via the BGLC's requirement to be able to see my database. Do I still have to ask that European supplier to be registered with the BGLC?
Remember, sir, that the objective is to ensure the integrity of whatever it is that is being provided. And those types of international companies that you speak of would be very much accustomed to the fact that whichever jurisdiction they're going to supply to, they would have to be registered with them. And the BGLC uses both Gaming Laboratories International and BMM, which are internationally recognized certification laboratories, which test hardware and software in the gaming industry. And it also, through its association with the International Association of Gaming Regulators, has a sort of participates in a sort of a network as regards due diligence. And they're moving towards a situation whereby if an international operator has satisfied due diligence, for example, in another international jurisdiction, they don't have to go through it all over again. It is accepted in a sister jurisdiction.
Okay, thank you.
Okay, thank you. Okay, we have one more question.
Good morning, everyone. My name is Pierre Shirley, and I've been involved in both banking and real estate, both here in Jamaica and in foreign jurisdictions. And I have a significant amount of familiarity with AML and anti-money laundering and the Bank Secrecy Act. And I'm not sure if there are some inconsistencies with the laws that are being implemented here, or if we are just lacking clarification and explanation. And to refer back to the questions that were raised by some of my colleagues here to my left earlier, I would like to expound on the question, for example, if an individual, and I'll kind of restructure the question, if an individual went into an off-track betting with perhaps maybe only $500,000, but they made a bet on the race, and the odds were more than 1, and they win, and they get paid out cash proceeds now of say maybe $1.5 million. That individual did not come in there in excess of $1 million, and now is leaving with an excess of $1 million. What are the responsibilities of the OTB Center, and what is the responsibility now of that individual who is now going to go to the bank with that money? Typically, the purpose of AML and BSA is to establish a paper trail. So typically in other jurisdictions, that individual will go to the bank and he would report to the bank that he got that money from this specific OTB, and the bank would get a corresponding report from the OTB indicating that they paid out that money to that individual, and then everything is fine. All parties are satisfied as to where this money has come from on the paper trail, and then there's no issue. And perhaps we need to just make that clear, that if that is the case, that there's really nothing that our gamers and our OTBs need to be worried about. And if that's not the case, then we really need to get a better understanding of the situation.
Okay. Would you like to respond?
Well, firstly, what I would wish to indicate is that in other jurisdictions, these OTBs would not make a payment in cash of that magnitude because they're stringently regulated. And so the difficulty that I think we are having here is that you can pay the winnings of 1.2 million, but not in cash. That is the critical thing, not in cash.
Okay, thank you. We're moving towards a cashless society. Okay, final question in the back there. Gentleman with his hand up.
Hi, good afternoon. My name is Carl Gowdy from Post to Post. The question is in relation to the unlicensed gaming machines. And it's two aspects I have. Firstly, machines that are unlicensed, as a fact, will be in establishments, but they're turned off, supposedly not being used. Are those, even though they're not licensed, will that be tolerated by the BGLC? Meaning the machines will be there, not licensed, but turned off. When the BGLC turns their back, the machines are turned on and used. And the second question is in relation to the traffic system, the traffic ticket system. And well, we're all aware that there is some semblance of corruption with the police system. What steps the BGLC has in place for any kind of whistleblowing, and what do you have in place that will deter your inspectors from taking bribes to facilitate these unlicensed machines?
I'll take the machine question. It's not known to take the ticket. All component or part thereof of a game machine is illegal if it's not licensed. So even if it's a shell, an outline of a machine, if it's a button, it has to be licensed. It cannot be on the premises.